Okay, I think we're ready to start here. Um, the online folks, I'm gonna try to accommodate you when we get to gameplay, but I've been told we don't have breakout rooms. So we might go, for you, this might be a text-based adventure with the chat. So we'll see how that goes. Welcome, everyone. If you're just arriving or you didn't grab one on your way in, there are some dice and zines that you can grab. My gift to you. My whole family helped fold the zines and staple. Yeah, 6-year-old folding. She would relegate it to the staples. So, all right. Hi. Well, welcome. What in the heck have you gotten yourself into? Well, let's find out together. We'll just start this off, sort of level set, and also this is really just sort of an age check on everyone. Shall we play a game? All right. Okay, so we've got the right people here. So what we're going to do today, sort of in a couple of parts, is I'm going to give you an origin story about how I came to sort of put this stuff together, and this stuff being using role-playing games to help teach law. Then we're going to have a surprise argument. That doesn't make sense now, but it will soon. Then we're going to get a little help from my friends, some of which may be computers. Then we're going to play a game. And then Robo Socrates lives. And I'll just let that sit there as a mystery. All right, origin story. So last fall, I taught a class. I assume you know who I am because you signed up for the thing, but I teach at Suffolk Law School in Boston. And last fall, I got to teach a class on AI in the law. And I thought it was going to be really fun. It was really fun, but I had to ask myself, how was I going to teach these sort of emerging topics in law? And how was I going to do it within the context of sort of the changing educational landscape where, everyone has access to things like ChatGPT, et cetera. And it seemed that it was very clear that I was going to need to use AI in my class on AI in the law. And I wanted to be very thoughtful about how I did that. And I wanted, what I really wanted is I wanted my students to walk away from the class and think that their AI class was the most human class they had. And so I got to thinking, how am I going to do this? And the other thing that came up was, well, what is the case law here that we should be looking at? Because what we're really dealing with is a bunch of ongoing cases, none of which has really been determined yet. And so I thought about, we know the case law method, we know the case method. I thought, let's do the RPG method. Oops, getting ahead. So to sort of illustrate what that is, I'm going to need a volunteer, 2 volunteers. Nice. Okay, 1, 2. You don't know what you volunteered for. So let me just, I'll put a caveat in. Who would volunteer to be able to give a silly legal argument in about 30 seconds on the spot? I'll let you read. I forgot who volunteered. Who volunteers? Yeah, okay.
I specialize in silly legal.
Silly legal arguments. Okay. Okay, very good. So we got Craig and say again? Dan. Okay. Here we go. A hot dog is a taco. Craig, can you please give the argument for why a hot dog is a taco? And for the people online, I will bring a microphone.
Well, a hot taco is simply nothing more than some sort of protein or other filling wrapped inside a carbohydrate. And a hot dog is nothing more than some kind of protein wrapped inside a carbohydrate.
Ergo. Okay. Hot dog, not a taco.
Well, let's define our terms here. What exactly is a hot dog? What exactly is a taco? Meat surrounded by carbohydrate. Is my chicken sandwich a hot dog? Is my chicken sandwich a taco? We must define our terms, and in the presence of ambiguity, we must defer to precedent, which says that they are not the same.
I like that. All right. So we've just had,
Get rebuttal? Come on.
no rebuttal. All right, let's see how many of us are there. 1, 2, 3. Okay. Now what I want to do is I'm gonna poll you guys. How many people think that our not a taco argument should rule the day? How many people agree hot dog not a taco? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Ooh, man. Okay, I'm gonna do a little math later. This will be done for you. All right, Greg, you have a D20 dice there with you. You need to roll an 11 or higher in order for your argument to succeed. A 2. So now I get to narrate it here. I feel like, well, the two parties came in, they argued, and one prevailed, and it was the question of what really is a taco? We can't say these things. So hot dog, not a taco, is the ruling of the day. Now, what we've done is we've taken a situation and we've been able to start to build up. And what I would do is I would do this with individual cases. And so what I would tend to do is I'd go and I'd find, and all this is explained in the handbook you have, sort of in more detail, but you're going to learn through doing here in a little bit. But and I'll move on just because that QR code is not your QR code. Here's the QR code, if you had so wanted to. But the basic idea is this: you find a case. I've been using the Free Law Project's docket a great deal. And what I would usually do is I'd find a case that goes all the way up, at least through motion to dismiss. And then what I would do is I'd have my students act as attorneys on the case. And so 2 students, although I think next year I'm going to do 4 students, so I do teams of 2, would be attorneys in a case. I'd say, here is the complaint, here is the motion to dismiss. You guys are this side, you guys are that side. And the first thing that they would do is they would build a case sheet. And did I include, I think I got rid of my picture there. If you open up to the middle of your zine, you'll see a little sample case sheet. And there you've got our friends duty, breach, causation, harm. And the case sheet is just a way to structure the argument. So the first session, and I would do this sort of asynchronously with students over email, is another way you can do it. You say, let's build up this case sheet. And so that first column are basically the elements. Well, not basically the elements, they are the elements. So you have them argue back and forth in email. What are the elements that are involved here? And at the end of the day, usually I just go with, okay, let's adopt the jury instructions, if there are relevant jury instructions. And then also I ask them to think, okay, well, what are you going to have to do to prove those elements? How are you going to get that in? And so the additional columns are effectively the witnesses. And I use the witnesses as vehicles to get in any evidence. And so I play a little fast and loose with the procedural rules here, having them sort of start with jury instructions and the timing and stuff I'm playing a little loose with. But the basic idea is I'm trying to get them to build this case sheet and say, okay, here's what I think, get them to agree on what the elements are, what evidence they would like to try to bring in. And then we come together and we do something very much like we just did. And I'll have a motion hearing. And that motion hearing will then be like, okay, well, here we are. What motions do you like to do? And so they'll say, oh, I like to do a motion to dismiss. And we'll just go through the motion practice prior to a trial. And sometimes I'll just say sui sponte, I'm just getting rid of those claims there because that's not what I'm interested in. And we'll go back and forth. And so we'll have a session, maybe about 30 minutes, where we go through and we do motions. And then the next session that will come up, and those motions will change the way that case sheet looks. So we might cross out some rows, say, okay, well, this was dismissed. We haven't yet determined what witnesses come in, or what the evidence comes in for the witnesses. We've determined the witness list. So maybe there was a Dalbert hearing in there sort of very quickly. And you can control turn a dial up on the level of fidelity you want for your simulation. So you can just be like, oh, here's your argument, this is what happened, this is what comes in. And the idea is that you're using this little bit of randomness and the feedback of the rest of the class to help shape the procedural history of your case. And so we build that through, we do motions, we then do a trial in the same, so it's like, oh, I would like to bring in a witness. Okay, what would you like them to do? Well, I would like to do a cross on this witness, and I would like them to admit they ordered the code red. And I'll say, well, that's really tough. That's you have to roll a 20 to do that. And so we build the factual record, and then we get all the way to appeals. And so we'll have the trial. Again, we have the rest of the class in that case can act like a jury. We'll have jury deliberations. The details of this are sort of all in the book, so you can dive more into that, and you can adapt this anyway. But the basic idea is just to provide a way that allowed the students to engage with the cases without them having an outcome already, and to really engage, to know like, okay, what are my arguments going to be? What am I going to have to say about this? And so you have the case that you're on sort of call for, and it's also a way to trick people to be on call, and they don't even realize they're on call. Like, so you're the attorney, you're effectively on call. Everyone else had to do the reading because you're going to be these sort of fractional judges. But you really know it when you're the student doing the attorney part, and then you come in and you build that case. And I just think it's a lot of fun. So what we're going to do is we're going to go ahead and we're going to see how this works by doing. And so what I've done is I've built a little tool to help walk you through this. So maybe like, oh, I can't remember all these rules, but we've got a little online flow chart. You're just going to click through. You're going to say what your role is, and it's going to help walk you through. So what we're going to do is we're going to break up into, we can do this a couple different ways. There are enough people here. I think what might really be fun is to split up into some smaller groups and do this. We also could do it as a whole group. Let me first sort of describe sort of what are the possible cases we could work with, and then we'll let people figure that out. So I anticipated wanting to maybe be able to split up into groups, and so I put together 4 different cases we could work on. And if you go to the URL that you get there from that QR code, which is just lawrpg.org/CaliCon2025, you'll get a helpful little helper. And it's going to ask you, what role are you going to play? So we're going to get in our groups. There's going to be one judge, who's like the judge, who's the one running the game. This would be sort of your game master, if you're thinking about this in tabletop role-playing terms. Then you're going to have 2 attorneys, and then everyone else is going to be a fractional judge. They're the people that you're going to actually have to convince. And if you click on your role, it will then walk you through what you have to do. So if you're the judge, it will tell you, okay, now take an argument, okay, ask whether or not, have the 2 arguments, ask people if the non-moving party should win, and then have the moving party roll a die above this. It'll do the math for you and everything. The key is, well, what cases are we going to use? And so the thing about this is it's not just a game, it's a sense-making activity. So this is an opportunity for people to engage with cases in a way that helps them make sense of them. And so actually, if you click through onto any of those case bits, what you'll end up at is something that looks a lot like the weekly activities I'd have my students do. And you have several different possible little AI bots that I built, which allow you either to sort of question the documents. Okay, so as I uploaded the complaint and the motion to dismiss, or in the case of the preliminary injunctions, some other documents. And basically, it can summarize for you what's going on in the case, and you can ask it questions. And so what we're going to do when we decide to break into our teams, we'll take like 10 minutes, and you'll read up on the case. There's no way you could do this without the AI, because some of these cases, like the net choice one, that's like over 100 pages of documents that it's interacting with. And I have my students do this, and those students who are doing the acting as attorneys, they actually have to move the case before one of the bots. So one of the bots will act as a judge. It'll say, okay, what side are you? Okay, make your arguments, and it'll ask some questions and give a little feedback. Now, you might be going, oh, no, it's going to say all sorts of wrong things. And you're right, it will. And so this is the key thing. This is if we want to talk about a little bit about AI, I'll just put this out there as the thing that was most sort of transformative for me. One of the things that I also do is I have the students do a weekly reflection, And I have that sort of mediated by one of these bots as well. And so it sort of asked them a question about your week. What did you work on? What was hard? What was easy? That sort of thing. And what I have my students do when they're either sort of skimming the case or doing their weekly reflections, they have to share those transcripts with me. And then what I do is every week I would read through the transcripts, I wouldn't have GPT do it. I'd read through the transcripts they had with GPT, and then I'd leave a comment in our learning management system to the students. They know that I'm actually engaging with it. It's not just them talking to a robot. And then I would, and this is the most amazing thing, on the sort of question and distill, students would come in, they'd upload the cases, they'd talk to it. And for the first time ever, it's like I had a window into my students' mind. I could see how they approached the case when they came in cold, what questions they were asking, what assumptions they were making, and where either they or the bot went wrong. And then I could address that later in class. But it was this, just for the first time ever, I was able to actually see how my students were approaching the material when they started to interact with it. And that really was, it was like this revelatory thing that just made every week a joy. And so, some people, there's a sort of a thought, oh, if you just have GPT, all I can do is have it write essays for people and you don't know what people are thinking. Here's a use case where you get to actually see how people are thinking. And then of course, the thing is, we go through and do a whole bunch of stuff in the class. You don't just do this. you would question and distill it, use that to orient yourself to the case. And then you go through and you have to read all the documents. And you can sort of see where that, and when you're the attorney, you really have to do that because the other side's adversarial against you and they're going to come at you if you haven't. All right, so I've traveled on much longer than I wanted to. I have 4 cases we can choose from. The first case is very topical. It's a JGG v. Trump, which is the case of, it's these El Salvador cases. This was the one of the ones in which it appears that we may actually have entered into a constitutional crisis because there is a court order and possible contempt for not following through. This is the facts as they existed at the first preliminary injunction, where folks were saying, hey, these people should not be removed under the Alien Enemies Act. If they're on a plane, turn the plane around. Spoiler, they did not turn the plane around. And that's a fun case. The reason I put it here is because it's this activity can be a sense-making activity. If you haven't read those primary documents, this is an opportunity for you to engage with them. But someone told me, like, well, maybe people think that's a bummer and that won't be much fun for a game. In which case I'm like, well, okay, I will find a case where both the left and right are wrong about the law. And so I went with NetChoice LLC v. Bonta, which is the age-appropriate design stuff out of California. And that's a very long, big case. And then we have Henderson v. Stability Fusion. That's one about training on images for AI image generation. And of course, New York Times versus Microsoft, or New York Times versus OpenAI. There are a lot of parties after that name. And that's not only on the training, but also on the output. And that's an interesting one because I believe there's also now an order now to preserve record. Anyhow, these are all back at the motion to dispense, this motion to dismiss posture or at the preliminary injunction. And so I guess what I could do is ask how many people want to do which case, and then we could use that to break up in the groups. Does anyone have any strong feelings? Would anyone want to do JGG v. Trump as a case? No one's interested in that. It's okay, it's pretty one-sided. NetChoice, who's interested in that? We got one NetChoice. Okay. Stability, no one's gonna be, there's gonna be like 2 people when we add it all up. Stability, Anderson v. Stability. Oh, okay, that might be a group for folks. New York Times versus Microsoft. Ooh, everyone really likes that. Okay, so you know what? Let's do this. I think those are 2 distinct groups. Let's have this side. What? Why do we roll? Well, I was going to just split it into 2 groups, but that is always the way to solve a problem. My kids, I built an app. It's linked at this bottom here, the dice one. You can make an inside a dice of your own, however many sides. I use that to solve disputes with my kids all the time. So who's gonna shower first? Roll a D20. And then it's like an initiative check. Whoever gets the highest, gets to choose. Best parenting hack ever. I can't choose which of these options. How many are there? 5. Okay, let's roll. So let's just make this side New York Times be Microsoft, and this side Anderson be Stability. So let's get yourself into little groups, and then what you need to do is you need to choose a judge that we can roll for. Who wants to volunteer to be a judge? Are there judges? Is there a New York Times judge? Someone who wants to run the game? All right. Is there a Stability judge? I can step in if no one wants to do that. Okay, I'll help run Stability. And then, so let's get into our groups. Give yourself about now 5 or 10 minutes to read up on the case. And then we'll choose attorneys, and then we'll just follow the instructions on there. We'll come back at somewhere between 15 and 20. We'll talk about our experience. I'll show you how you can build some of the stuff. If you have questions, normally I'd go back and forth, but I think I'm going to be a judge over here with Stability. So I hope New York Times feels confident. Okay, Stability, and you're going to have to get in a group with each other and talk to each other. And yeah, well, it depends on how many, if they're. Yeah, so a lot of people will be fractional judges, which means you're going to have to be convinced of the arguments. All right, people online, you can get to that tool at lawrpg.org, CaliCon 2025. I don't know if you guys can reach a consensus on what topic you might want to do. If you can, and if you have critical mass, you could run the game in the chat. I'm not sure what it looks like over there. Elmer, do you know? Do we have people in the?
We have like 2 people.
If it's 2 people, you're probably not you're not going to be able to run the whole game. So for those of you online, I don't know, you might want to eavesdrop on us while we're here, or look through the materials, but we'll be back between 15 and 20. All right. Okay, your judge. First thing you need to do, the judge is going to help choose some attorneys. Then once you all know whether you're not attorneys or fractional judges, read up on the material for New York Times, Anderson, and then a little after the top of the hour, start your game. And if you have questions, you can come grab me. All right. Does the judge over here feel confident in your ability to? All right, great.
Yeah, I'm good.
All right. All right, we need to actually get around so we can all hear each other. You need to huddle up. I'm thinking maybe I should make a third group. I don't know. Now you guys can all hear each other. All right, can everyone I just want to pick some attorneys first, and then we can go reading. Is there any 2 volunteers for attorneys?
And then the address.
It's really much easier if someone volunteers.
Rounding the rules and process, so.
Okay, first we'll discuss that and why we're doing it.
Yeah.
So who would like to be an attorney? You're gonna make an argument.
Make an argument.
Okay, and you're Lisa and Matt. All right. So let's figure out who's gonna be. Which side?
So I clicked on the still.
Yep, the still in question. So now we should all read up. Let's take 10 minutes to read through, figure out what the case is about. And then we'll have Lisa and Matt be our attorneys.
So it's 2 attorneys, 1 judge.
2 attorneys, 1 judge. Everyone else is a fractional judge.
Oh, okay. So you have to do a complaint or.
Yeah, so you do not have enough time necessarily, might not be able to read the whole complaint, so you can ask questions of it in the chat. To say, well, what are the arguments, what are the elements? If you want to jump into the complaint, that definitely is what you would do if you had time.
And that's the distill.
Yeah, just go in question and we'll let you see all.
So what are the other three? Like, I don't know. Great.
Hotel. It's your car, so it's I'm gonna take this, someone doesn't volunteer. Alright, there's one.
You take my side.
You already, I already know you want Microsoft, anybody else want to be an attorney? Anyone wants?
Okay, but they're right, or I'm not a lawyer.
Neither am I, IT guy, alright.
I was transaction.
So a good place to start might be to ask, to list the claims, or to jump into the complaint and jump down to the claims.
All right, I'm gonna go, plaintiff or defendant. Oh, goodness.
I don't know if I'm gonna win after the hot story.
First, I want to talk about sandwich, but tell you what.
There we go.
I'm gonna roll one ten, I think plaintiff, and let's go when it takes it.
Alright, cool.
Over enthusiastically rolling.
But generally.
Since I am, I'll take new.
I might ask, like, list the claims. And you can argue on those. The big one's gonna be fair use. To ask the public, list the claims, and those are that. One,
I use Google if I wanted
you can
information.
use
outside of
whatever
social media.
information you like.
I don't want to cheat.
There is no cheating, and in fact, for my class, what people do is, this is obviously, they're not within this just walled garden. They might have to go do some actual legal research, to pull in things. So if you want to just for scoping, if you want to just deal with copyright infringement. Vicarious, probably the game of vicarious. Ask it, what are the elements of the vicarious copyright? Elements you ask. I think I've got it. All right. Another like 5 minutes on the reading. You can ask things like, what is the best argument for the defense in relationship to this? What is that? May or may not be right, but it's going to give you something to start with. And you can, of course, use your own knowledge as well. The attorneys you should know, I'm probably going to focus on either the director of vicarious copyright. Forget that DMCA claim. Dismissed. All is left. You have a laptop, that's, you know, a good way to get it too. Always look into the future by looking at the documents as well. Give it like another 3 minutes and then we'll switch over to gameplay.
Second cheering for Matt over here.
Very good, very good.
Well, you maybe defend a hot dog already, so.
Yeah, I figure you've spent your
Hot
time.
dog than Trump, so.
Yeah, that's true.
Had worse lines than hot dogs.
I think 1 more minute. We'll call court to the session. So for my fellow judge, we're doing motion to dismiss, so what I mentioned is one or the other. All right, I think folks are ready to go. If you guys wanna do, if we wanna do this like a round and I start off and sort of see what's going on here first, we can do that. So we have 2 attorneys, we have Lisa and Matt. We haven't decided what side they're before. Now you know about the case a little. Do either of you have a preference? We'll definitely roll for it if you don't have a preference, but if you have a preference.
Yep.
Not really. All right. And let's just do this, whichever one of you gets the highest roll will be New York Times.
Oh.
Oh, I'm sorry, Anderson.
And you still have this.
14, so we have Anderson, Matt is Anderson, and Lisa is Stability AI. In this case, this is a motion to dismiss. So Stability AI is asking us to throw out the case that Anderson has brought. For those of you over there, Anderson is basically saying they trained on a bunch of our art, and that's a copyright violation. Stability AI being a company that makes diffusion AI images. So what's this fun AI? I'm assuming a sort of, feel like a year ago I would have had to explain anything, but now I'm assuming this. So on the question of direct infringement as it relates to the training, why why stability do you think that, Anderson should have first, we'll start with the first element, which is the direct infringement. Why should they have that dismissed?
They did not register their copyrights. So the material that was scraped from the open web was open material because it was not properly copyrighted.
Okay, that's one argument. And here's where you could, this is not what I would suggest you do in real life, but you could crib things and ask your little bot for it. So we're going with so under direct infringement, they have to show ownership of the copyright. And in this case, you're saying basically there weren't any things that were copyrighted. I don't know, what do you say to that?
I would say that the case should not be dismissed on this ground because any failure to register can be cured.
I like that. Now remember the burden you're trying to meet here is you're sort of assuming the motion to dismiss stage that all the allegations in the complaint are true. And so the question, if we're doing motion to dismiss for failure to state a claim, then it's, you're saying basically everything they said is true, but doesn't matter because they didn't say enough for it to actually be this claim that they're making. So you're saying it can be cured. You might also argue that copyright attaches even if it isn't registered, just by the direction of something in ethics medium. And so what I would do is I'd then say, hey, judges, how many of you think that Matt and Anderson's argument is the superior argument? So how many think that it shouldn't, this one particular claim should not be dismissed on that ground alone? How many people think that is a superior argument? 1, 2. Wow. Okay, so 2. Really, people are buying that argument? Okay. So basically then what happens is I told him how many people are here, and I'm going to record the votes for the non-moving party. And so you have to roll a 4 or higher to dismiss the direct infringement.
2.
2.
Oh, shoot.
Okay, good, because that would have ended it right there. So that then we'd say, well, I have after looking at the arguments on both sides, I have weighed the arguments, and I do not feel that we need to dismiss at this stage. Counsel, do you have any other arguments?
The next one, I forgot what the next one is.
Well, you might have other arguments to dismiss the direct infringement, not just based upon copyright. So, that was based upon registration of copyright. So this is normally where you see in these copyright cases, the big thing comes about being an argument of fair use for the training. The main difference between the two cases, and I can see now that we're just sort of playing this all together as one big group. So that's fine. So I might engage some of you to be judges as well. So the main difference between the two cases, at least the one that I like to make the distinguishing difference is that in Anderson, they're basically saying there was copyright violation when you took in our images and used them to train your model. In the New York Times case, in addition to that, they're saying, well, not only that, but we got people to there's this whole long thing in the complaint about them getting it to recite New York Times articles. And so now they're saying it's not just about the training, but it's about the output, right? And so this argument about why would that matter comes up because there's a defense to normally for copyright infringement, right, there has to be some copying, right, that's taking place. And so there's this question, is the copying that takes place in training, is that really copying? For output, it's much easier to say, well, this thing that it output, is that a copy of the thing that was there? The argument, of course, in a technical sense, is that what happens is you ingest this data for training. Just to give you a quick back of the thumbnail calculation, if you looked at now here I've sort of stepped out of this. This is where you might be as a student, you might be like, how do these models work? You wouldn't talk about it in class. And I'd say, well, okay, let's do, in tabletop, this would be like a, do I know this? So can you roll your dice? You need to roll a 4 or above, and I'll tell you all about this.
10.
10, okay. So so basically the argument here very often sort of revolves around this idea of fair use, which is the idea that sometimes it's okay to copy things, and there are different reasons why that might be allowed. And one of the big arguments there is whether or not it's being used for transformative purposes. And so you might now have an entire argument about, well, is this transformative? And to what extent are these copies like sort of ephemeral? And so we would have read like the Google Books decision and some other relevant cases to come into this. But hopefully what you're starting to see is that we can develop a factual record for a case that has not actually gone beyond the motion dismissal stage. So we have these active cases with open questions of law, and we can build a factual record, which we then get to the point where we can have an appeal on one of the issues built upon a record that does not yet exist. And also, as you're starting to see here, I heard some people say, oh, I feel a little overwhelmed by all the stuff that we're trying to do. This is obviously a very compressed situation. What I would normally do is this is spread out over multiple weeks. You'd be able to build a thing. But hopefully what I really wanted people to do is to experience some of the fun of the uncertainty and the tactile nature of being like, I'm going to go in, I'm going to make my argument, and I think it's good, but I'm not really sure how it's going to come out. It depends upon sort of what's in the judge's head. In this case, your judge's head is sort of distributed among your classmates, and you have to convince them of the what does the law say here. And so it's a way to really engage students in this collaborative sense-making exercise. So it's like, what does this all mean? And also, I used to be a criminal defense attorney, and it goes back, like, how do you actually make a case happen? Right? You start with the elements. You figure out, how am I going to prove or disprove this? And this is a structure that gets people to start thinking systematically about that sort of strategy of how you take a case all the way through. So it's almost a trial advocacy class inside an AI class. And you can turn up the knob on how up or down on how high fidelity you want these simulations to be. We've been sort of doing it, we can talk about it sort of like in the third person and say, well, I would make an argument here. And that would be, that's fine. Or you can make it very much like Your Honor, like you can turn that up or down. But the important part is that students have to interact with the material beforehand. It's a standard simulation, but it's a simulation that involves the entire class. And that can be used to build a record upon which you can do more things. And I don't know, I think it's a lot of fun. I was hoping you have a little more chance for future experience on that, but I think that you've got the flavor. We have the book, so you can read that. Are there any questions or anything this time? I'm going to show you how you might do make some of these tools for yourself. Was that? I wanted people rolling dice and being like, which happens sometimes. And it's always fun when there's like that. You have to roll a 2, and they don't roll a 2. So there we saw that. We saw how you could talk to things, and then we played. All right. I'm entering my Clark Kent stage. It's my first conference wearing glasses because I was in my mid-40s. Apparently, I needed glasses. So I'm not quite sure what to do with them yet. Here in Kavar.
Yeah, LASIK, it's awesome.
Hey, but it's not very much. I used to have better than 20/20 vision, so it's all very weird. Aging. All right. Speaking of times long gone. So the tools that you interact with, there were sort of there are a multiple set of bots. There was one that was the distill in question, which allowed you to talk to the documents. There was one which actually would perform a Socratic method on the students. So it actually says, okay, in that case, so the distill in question, you might use that before you read. So you do that, use that to orient yourself, and then read the documents. For the Socratic dialogue, you would read the documents, and then you would come in and it would talk to you about the documents. And then there was this sort of weekly reflection. So students would always do one of those first 2, and then the weekly reflection. I used a tool that I built, which is a Firefox browser extension. And there's a blog post here that sort of jumps into a kind of like a 50 post series where I talked about using that extension to do all sorts of different things. This blog post talks about building that Socratic dialogue. And you can do this now with a lot of the major AI platforms. So if you have a pro account on ChatGPT, you can make a custom GPT. And basically what you do is you take your documents and you upload, there's a place you upload them. And then you say, you are a helpful legal assistant answering questions about these documents. And you basically give a persona to the AI, and then and you say, use these documents attached as that's what it is. And what I like about this is I built it myself, and it's very, I like to understand how things work. You can get right in, you say basically, really control things fine grained. You will, however, need an API access to an API for an LLM. You don't have to use ChatGPT. You could use an open model using through something called LM Studio, which would run like on your computer. There are all sorts of ways. That's all discussed there in the blog post. So basically, if you want to do this, all you're basically doing is saying, here are some documents, act in this role. And there are different ways you can build wrappers around tools. That blog post will show you one way of doing that. But again, I like to say that technology is not just digital technology, paper is technology. Universities are technology to some extent. So my hope is that people exit here today, maybe curious enough that they read through this zine and think, oh, maybe there's something here I could do with it. Or if you're interested in the sort of technical side of things, you can visit this. Also, in lawrpg.org, which is listed on the front here. That is the last year's syllabus is available there. And there you'll find a bunch of reading to things like this blog and instructions on how to make these sort of tools. And also you can see how it's sort of laid out in that first semester. This feels sort of like anticlimactic.
Question. You talked about the reflection assignments and how that revolutionized your teaching because you could understand what.
Yeah.
Do you read them yourself or do you have
Yes.
ChatGPT summarize them?
I read them myself.
Okay.
Very important. I don't think I'm very upfront about when I'm using a tool and when a student's using a tool. I ask them to be upfront about it. And I definitely know from other experiences that at my institution and other things I've tried, that if you, I mean, what are the stakes if I'm doing a thing and no one's looking at it? And the revolutionary part was the reflections are really just sort of traditional journaling exercises, right? So I teach in the clinical programs as well at Suffolk, and journaling is a long, has a long tradition. And the problem, the difficulty with journaling is the scalability, right? And so one of the nice things about this from a journaling exercise is it allows students who aren't used to journaling to be able to engage in journaling sort of because it sort of pulls some questions at them and asks them about things. But it's very just sort of for the journaling, it's very just like asking you questions. It doesn't have to be like it doesn't have to have much intelligence. It's just trying to get some words on the page. The revolutionary part was really the reading the transcripts and still question. Because journaling, you normally, you ask someone, what was the week? They'll talk to you about that. What was interesting about the distill in question was I could actually see their thought process as they engage with the material for the first time. So, they basically come and they get the complaint and the motion dismissed. And I can now see what questions they're asking of the document when they come in. And they, oh, I can see why you asked that question. I need to talk more about this next time. But I could also say that in the comment. I could say, oh, well, it's interesting you asked this. What about this other direction? But yeah, very important. I think that you read or a person reads those transcripts. That was the part. I think if it was just something in the dark they were doing, that would not have had the same effect. And then it also is really is about orienting you for the reading. So this is the process of skimming a text and then going in and doing a deep reading. you never replace that. And I think hopefully one of the things the students get, especially because of the adversarial nature of the arguments, is that if you don't do the work to actually read through the things and understand the stuff, there's someone on the other side who's going to hold you to account. And of course, we talk about things like the, all the various cases where attorneys are, preparing documents that they haven't actually checked. And I think that most of there's a lot of people like, oh, this is all weird, new stuff. We're trying to figure out things. We can't use this. We can't do that. Like, I think people just need to, we have not yet figured out as a society, what are the appropriate norms and best practices for using some of these tools. And we went through the same thing back with the, creation of the printing press, in that, there are people like, oh, this is getting out. How do you know something's true? How do you know this? And then we fought lots of wars, bloody wars that, anyhow, and that was because of the printing press. So who knows what's gonna happen now. But the point is, out of that came things like, okay, well, there are primary sources, there are secondary sources. You treat secondary sources in a certain way, you treat primary sources in a certain way. LLMs I like to think of as secondary sources once removed, right? So if you want to trust a secondary source to be the authoritative source, you might use that to find your primary source. I think you need to treat these the same way. Additionally, you wouldn't ask someone to tell me about a book they haven't read. So if you're asking, if you're just asking one of these models to tell you about, say, a book or an article, but you haven't provided the text of that article to it to read, then you wouldn't do that. And so the point is, like, there are things that that we're learning about these tools and how to use them appropriately. And I don't know, someone had a hand.
Give them any specific guidance on how to ask questions or feedback on the questions they ask, besides good
Yeah.
questions or interesting?
We had, so that post is part of was it 50? Yeah, 50 blog post series I did where I played with a lot of stuff in regards to prompting and dealing with these tools. I mean, the biggest problem with a lot of these tools, or the biggest challenge I think to educators working with these tools, is the thing that was true about them 3 months ago is not true about them. So people say, oh, well, they don't search the web. So, you can't, they can't tell you anything about the web. Well, that's not true. Some of the models now do, some of the tools do search the web. So you can use it to search the web. And so there are all these, oh, well, anything you put in it is going to be used to train the next model. Well, that's actually hasn't been true for a very long time, because there are contractual obligations in paid versions of these clients for that not to be the case, because people recognize that no one will want to pay them if their thing is going to let their secrets out. But then you have this thing now where OpenAI actually deleted the things that you deleted and wouldn't look at the things you did. But now there's a court order just this last week or a week ago, which now is making them preserve all of the inputs in contradiction of their own contractual obligations, which is sort of interesting, because now there are a bunch of people who are using the API on top of OpenAI who have contractual obligations. People have said that these things won't be saved, but now they're being ordered to be saved. Of course, OpenAI is challenging that. And so the point is, everything's a moving target. I know I'm rambling now, and I'm not sure how much that's giving. Other questions? Mostly I want people just to sort of think outside the box. Think of there are fun, different ways that you can package things and really engage with things and really be human-centered in your approach to using these tools. And I do think there's something to be said for the tactile nature of getting people involved, dealing with the tools, using some of them in your preparation to see where they fall down, where they might be helpful. And then there's a whole parallel track to the class where we actually learn about the technology behind the tools. But mostly I just wanted people to be able to have an excuse to play a game, and it was fun unfolding these scenes. Other
Question,
yeah.
in the Socratic method one you do,
Yes.
is that the prompt, is it requesting information from the student?
Yeah,
So
so
it's not a typical where it's waiting for you to ask a question, or
you are being put through the method. So it is performing the role of a legal instructor performing. So those tools, it has the cases loaded in them, and say, okay, explain, what was the holding? So it's the first scene from the paper chase. but, computerized. Although we're not talking about a hairy hand, it's whatever case you want. And so I always find it interesting when the students choose to do this one. They can choose, they have some choice. The other means they have to read the documents first and then do this. So it's a way for them to sort of test their understanding. The distilling question is where most people go, because that's sort of the easiest entrance in. Although when you're the attorney, and I talked about it, there are only two, there are three. It's also, you can moot it with a judge, with a robotic judge. And there it will act like the judge and say, okay, tell me what side you are. And say, well, I'm this side. Say, okay, we'll make your argument. And then it will push back with some questions and give a little feedback. And if you're acting as a student attorney, I think that on that.
You were talking about looking at the transcript. Are you seeing that live, or is that something you just look at that later?
I look at that later. So they load that. So basically in ChatGPT or in the tool that I made, there's an artifact that you can share of the transcript. So sometimes it's a link, sometimes you have to download an option. And I have them put that in our learning management system. So it's an assignment every week that, give me your 2 transcripts. And so I just go into our learning management system, and then I, open up all the transcripts and I read through them. And then I comment back in the learning management system on the assignment that they had done. I said, oh, I see you did this. It was very interesting to see how playful the students were with this, especially at the beginning of the year, where they try to do things where like they, I think they wanted to make sure I was reading. That they play with the LLM, they, do like, ignore all previous instructions and, do this thing. But that playful nature was, I think, a lot of what I think made it work in the class, is because they knew that we were all doing that together. But it really was, it's hard to overstate how, because you see that thought process of how someone's interacting with the case for every one of your students. There's a seminar class, so it's, not that many folks or something we do, so it's not so. But it was just because you have those students who you don't know normally until the end of the year what they're thinking, and now you know what they're thinking while they're reading things. And that was just really revelatory to me as a use case. All right, I think we're at our time. I'm happy to chat with folks in the hall other times throughout. If you want to take a couple of dice home for your kids or your friends, I have way too many. I'll use these again next year for my students, so I don't take them all from me, but I don't feel like you only have to take one and take some zines. There was a lot of folding. My family's gonna be very sad if I come back and they're like, way too many zines. I'll be like, why did I do all that folding?
Thank you.
Thank you.